Well, good morning, everyone, and welcome to our first virtual breakfast. We know that many of you enjoy our monthly breakfasts at Vic Park, and so with all the uncertainty around when we were going to be able to hold another one of these, we decided to try a virtual breakfast. Whilst we cannot provide you with bacon and smashed avo or the nice view of the golf course, we can provide you with the latest industry news and advice from our experts, who this morning are Ted Williams, partner from Piper Alderman, and Matt Smith, principal lawyer at DWF. So today's breakfast is unsurprisingly focused on COVID-19 and how it's affecting industry. I'll shortly run through a few of the formalities of this virtual breakfast before introducing Ted, who will talk about COVID-19 from the point of view of contract responses and strategies. Ted will be followed by Matt Smith, who will be talking about HR and IR related issues. Finally, I'll provide an update on industry news, including some of the good work that's going on behind the scenes to keep our industry operating and to provide increased support to the economy when we get through to the other side. This breakfast is scheduled to run for about 60 minutes, but may run over if we get quite a few questions that people would like to see answered. Unlike normal breakfasts, I'll also be providing an opportunity to ask me some questions on the updates that I'll be providing at the end of the presentations from our guest speakers. We'll also be recording this breakfast, so if you need to duck out to tell the kids to keep quiet, or to go and take delivery of that emergency case of Shiraz, don't worry, you can always watch back later and see what you've missed. So, the rules of a virtual breakfast: make yourself comfortable, keep your microphones on mute, and please submit any questions that you have through chat. We'll try and address questions, please address the questions to everyone. I think there's a function through Zoom where you can address the question to the particular speaker, but I'll be moderating those questions. So if you can address the questions to everyone so I can see them, that would be great. So I'd now like to introduce our first guest speaker, Ted Williams, partner at Piper Alderman. Ted is an infrastructure, construction and mining lawyer with more than 25 years experience in both private practice and general counsel. Ted's international experience has been gained in a wide range of projects, including projects in the PPP, mining, road, rail, energy, resources, wastewater, manufacturing and pharmaceutical sectors, and on educational, commercial, retail, sporting and residential developments. His expertise includes contract preparation and negotiation, procurement, joint ventures, consortium agreements, advising on project risk, claims management, dispute resolution, environmental and safety compliance, professional and contractors indemnity, workplace relations, insolvency, governance, and anti-corruption. His clients have included government, developers, sponsors, contractors, operators, financiers, and consultants. Ted was previously general counsel at TEAS, one of Australia's leading mining and service contractors. He has led a large team in delivery of legal services across the Asia-Pacific region, providing legal, strategic, commercial, governance, corporate, compliance, ethics, and risk management advice at all levels to the business. In addition to this work in relation to large-scale infrastructure, construction, and mining projects, Ted has advised on a wide range of legal issues, including commercial law, mergers and acquisitions, governance, dispute resolution, employment and industrial relations, environmental, health and safety, and anti-corruption control. Ted advises participants at all levels in the delivery of construction, mining, and infrastructure projects, and has held partnerships in law firms in Europe and Australia. So Ted, over to you.
Thanks, John. So by my count, I've got about a minute to go after that introduction, so thank you for that generous introduction. Look, I think one of the things we all recognise with the current pandemic crisis is that this is going to test our relationships and test our contracts greatly. My view from where we stand at the moment, when we see hopefully the curve flattening, is that these things are not going to be resolved now, but we can take steps towards resolving them now by proactively engaging with our clients, and that needs to be backed up by a detailed understanding of our own contracts and the risks and obligations that sit underneath them. But also, one of the messages I want you to take away from today is that when we're dealing with this issue of COVID-19, making sure that we take a particular emphasis on establishing cause and effect in respect to the impacts of that, because I think that's where the problems will come down the track. So if you give us the next slide, please, John. So we're going to cover briefly the key legal concepts, some practical responses, and in keeping with the government's theme of a hibernation plan, a few ideas about how that can be managed in the construction contract context. Next slide, thanks, John. One of the things that I think we will come to understand out of this crisis is that the boilerplate contracts that we tend to use and the clauses that are there and well established didn't see this coming. In other words, I think contracts have been shown up by this crisis not to be fit for purpose. And I think one of the enduring outcomes of this will see quite a significant change in the way in which contracts are drawn, taking into account the lessons learned from this. Why is this so? Well, it's because standard form contracts are largely products of precedents. They're based on parties' recent experiences and historic experiences, and they reflect the true bargaining position of the parties. There's a myth within contract law that parties are assumed to have equal bargaining position. We all know in the construction industry that's not the case. The terms are largely set for you and you need to bid against those terms in a competitive market. So in recent years, I think we've seen contracts become less of a management tool and more about allocating risk or transferring risk rather than managing it. And I think hopefully out of this, we'll see more of a move to actually properly managing risk. Because the fact is that unless this is recognised in this context, construction companies will fail, and many construction companies will fail without proper relief. And the ultimate risk will manifest because projects won't be built. I think we're seeing early signs that government in particular recognise this and they're looking to change their own contracts, but time will tell. Anyway, the signs are good so far. So we're going to cover in concept the idea of force majeure relief, frustration, change in law, and the general concept of delay and extension of time, and also suspension and termination. So next slide, please, John. I'm sure a number of people listening to this presentation today will have heard people say, or may have said it themselves, that they've declared force majeure. Well, what does that mean? In short, if force majeure isn't recognised in the contract, it doesn't mean very much. Force majeure isn't a universal legal concept. It is actually very much a product of what the contract says. If there isn't recognition of the concept in the contract, you don't have any rights arising from it, frankly. It's often expressed in different ways. It could be called the force majeure event. It could be an act of God. It could be a material adverse change, or it could be described as an event beyond the control of the contractor. So they're the sorts of words you're looking for if you don't see a force majeure clause. As I've said, it's a purely contractual beast. So unless there's contractual recognition for it, there won't be relief. It provides in normal context relief for unforeseen circumstances beyond the party's control. Usually, you'll see where there is a force majeure or similar event, it's defined by reference to a very limited list of events and types of events, and relief only exists for those sorts of events. The relief is often confined to limited circumstances, and in many cases doesn't necessarily include effects that happen down the supply chain. It really mainly responds to effects that happen on site. And as we all know, hopefully at this point in time, the effects on site are less, and that the overall impacts on the supply chain. One thing that you do need to realise is that it's subject to the normal, usual notice requirements. So it's important that people give adequate notice of these things happening when the notice requirements are enlivened. And also, your relief is subject to establishing what us lawyers call causation. So it's not good enough to say, for instance, a force majeure event has happened, I can't pay you. You need to be able to say a force majeure effect has happened, it has impacted my ability to pay for this reason. So causation is really important thing to establish. Typical relief in construction contracts are extensions of time, sometimes mutual rights of suspension, sometimes one party's rights of suspension, and in extreme cases, termination of contracts. Next slide, John. Frustration, as I said, frustration is a slightly different concept to force majeure. It exists in common law and in some statutes. Victoria, New South Wales and South Australia have statutory recognition of the concept of frustration, although it doesn't exist in Queensland. As I said, the common law will intervene to effectively put a contract at an end where through no fault of a party, an intervening event has made that the performance of that contract impossible and fundamentally changes the obligations that you originally contracted for. It won't arise where there's a mere, the concept of frustration or force majeure is otherwise recognised in the contract and provides remedies. In those cases where there is that recognition, you move away from the common law and look to what the contract has to say. And it won't also arise for mere change in circumstances that make performance of the contract more difficult or more expensive or delays it. So you've got limited remedies there. And particularly where change is temporary and the term of a contract is long, it's very unlikely that an event like COVID-19, where it will only be a temporary event, is likely to give rise to a frustration. Frustration, on the other hand, can arise where the change in law renders performance illegal or the subject of the contract is destroyed. For instance, a force majeure event could destroy a building you're working on, or performance is otherwise restrained by act of law. So next slide, please, John. Change of law is very much similar to force majeure. You often find contracts that recognise a change in statutory requirements or a change in law or a change in government requirements as giving certain relief. Like force majeure, it will only be, its operation will only be limited by the terms of the contract. Typically, these clauses contemplate unforeseen legal requirements which occur after the time of tender, which affect the ability to perform rights. They relate to change requirements of government authorities, and they may extend also to change requirements of overseas governments which impact the supply chain. And the clauses often provide for their rights to claim additional costs, extensions and suspensions and termination. But again, it depends upon the operation of that contract. In Queensland, where we've seen government directives on non-essential business activities, home confinement and border restrictions, they have arisen by operation of the Public Health Act in Queensland. So it will be important if you're going to identify a change in law which is affecting you, that you can go back to the source of that law, which is that act. Next slide, thanks, John. Suspension and termination are rights which will often flow from the occurrence of a force majeure event or a change in law event. It's important that people understand that they do not arise independently of the contract. They are subject to contract terms. And it's very important when you're thinking about exercising your own right to suspend or terminate, that you do it strictly in accordance with the contract. And I would suggest you need legal advice about that. In many of the force majeure clauses which I've seen, the right to suspend in particular and to terminate is unilateral. It's usually a right of the client rather than a right of the contractor. And it's important to recognise the limitations of those sorts of rights. Now, a failure to perform work or a mere suspension without recognising a right creates huge risks for a contractor, I would suggest. It's likely to constitute a willful default. And where you're commit a willful default, it will usually expose you to all sorts of liabilities. In particular, you won't have the benefit of any cap on liability, which you may have negotiated in your contract, because it's usually an exception to that. Next slide, John. Again, delays and extensions of time, none of these things will be concepts which are foreign to you. Again, you'll need to look at your contracts to see what extension rights you've got and what extension events may apply. Again, causation between the actual event, such as COVID-19, and how you're affected is really important to be established. Concurrency, where there's an existing delay for which the contractor has assumed the risk, you can be sure that in most cases you will not have an entitlement to claim an independent and concurrent right of delay where another event has already delayed completion. It's really important that we understand and comply with strict notices of notice requirements. A failure to provide timely notice will in many cases void a claim. So in our contracts, we should look at identifying hard completion requirements and dates, the sorts of delay damages which apply to those, looking at time of the essence provisions where they apply. They don't usually apply in construction contracts. And in larger projects, I think we need to be mindful of this concept of look forward tests, where a principal can make an assessment early in the project as to whether or not you're going to complete on time, and may have rights arising from that. So it's important that you consider those things as well. John, next slide, thanks. Look, in looking at how standard Australian contracts respond, I think it takes me back to something I said at the beginning. It's clear that standard Australian contracts are not fit for purpose here. They do not do what they are meant to do, which is allocate risk. Rather, they assign risk, and the risk of something like force majeure is a risk that no party can manage on their own. So when you compare two significant contracts in our industry, the Transport and Main Roads, Transport Infrastructure Contract and AS 4902, the Australian standard, you'll see that they're very similar and they don't recognise force majeure events. The TMR contract thankfully does give relief for delay, which is beyond a party's reasonable control, which is likely to cover this sort of event, whereas AS 492 doesn't provide for this sort of event being a qualified cause of delay. Both contracts provide for change in law requirements, which are valued as a variation, but they don't necessarily provide time relief. They do expressly recognise concepts of frustration, but only to limit a contractor's rights of claim in those events. I'll have a little bit more to say about Transport and Main Roads contract later, because we're seeing some early signs that I think Transport and Main Roads realise the gap that exists in their contract and are looking to provide some assistance to contractors to make sure that that risk is previously managed. What's proposed, I think, what will be proposed is an amendment to the contract. And the early signs are that it will encourage open communication and mitigation of risks, and will look to provide time and cost relief, rise and fall, and suspension rights to the client in respect of these relief events. So next slide, John. So key actions now, I think, is you need to, if you haven't already, and many people would have, review your contracts to see how your contracts address these concepts of frustration, force majeure, material adverse events, change in law, delays and extensions of time and notice requirements, and emphasise that notice requirements are really important. You need to check the limits of relief and whether or not it's merely confined to actions on the site or across the supply chain. You need to identify whether your subcontracts and supply agreements are back-to-back and provide your clients with equivalent rights, or provide your subbies with equivalent rights, or God forbid, provide them with more rights than you have. If you have that situation, you're in a bit of a bind. But most competent contractors won't be in that situation. Next slide, thanks. It's really important to emphasise that failure to give notice can be fatal, and failure to give proper notice might be fatal. But what I would say to you is, if you haven't given notice today and you should have given notice, what is definitely fatal is giving no notice at all. So from a risk management point of view, you should give notice regardless of whether or not you've met the strict time requirements. It's the Western Australian case of 2015 of CMA Assets and John Holland, which says that failure to meet very strict notice requirements, including information about cost and time effects of events, failure to give that it can be fatal to a claim which is otherwise valid. So typically notices require you to provide advice as soon as you become aware, and oftentimes there are separate notices that to notify of the delay, the particulars of the extension event, the consequences and likely consequences of those events, and to estimate the numbers of days claimed and the costs claimed. And if you can't estimate that, you've got to, my advice to clients is to give it your best guess. And you need to recognise that in many, particularly private contracts, contract with non-government entities, there's an obligation to repeat that notice every 7 days or 14 days that the delay event endures. So it's really important to make sure that you've got your ducks in a row in terms of these notice requirements. Next clause, thanks, John. So the government's talking about hibernation. Why is it a good idea in construction contracts? Well, one primary reason is that we are in the middle of this now. We aren't at the end of the process, we're in the middle. And we will need to, we'll get to the end one day, but in the meantime, contracts and particularly notice requirements oblige us to create a lot of paper, which is in many cases, I think, unethical to actually getting things resolved. So I do think that by engaging with their clients and having good open communication, contractors should encourage a hibernation plan. It doesn't mean that works are necessarily hibernated. It just means that sort of the mechanisms of the contract and the notice requirements might be put on hold for a period of time. Next slide. How do we do that? In many projects that I'm involved in, we've entered into what's called a standstill agreement. I'd prefer it to be a deed because of legal issues about consideration. It needs to be enforceable, and unless there is proper consideration, such an agreement is enforceable. A deed, on the other hand, doesn't require consideration. But this is envisions to provide breathing space to clients and preserve rights without necessarily engaging in the back and forward of contract correspondence for a period of time. And it's a good standstill agreement will recognise the mutual difficulties the parties are having, suspend the giving of notice and the laying of blame without prejudice to the parties' rights in the future, promote practical engagement and solutions, preserve the parties' rights for a defined period of time. And I'd suggest that that would be for the period of the pandemic or a set period, perhaps 6 months is what the government's talking about at the moment. It doesn't mean that the works are suspended, it just means that the argy-bargy, if you like, of the contract administration is suspended for a period of time. Next slide, thanks, John. All of this is pretty quick. I'm sure you'll have some questions. I'm very happy to answer those. And there are my details. So thanks very much to QMCA for the opportunity.
Thanks, Ted. I'm looking through to our Zoom chat. I don't see any questions coming through, so please get those questions in whilst you're doing that. I've got one for you, Ted. Do you see this event as being an opportunity for essentially a reset in how parties contract going forward?
Definitely, John. For a long time, I think the industry has been saying that the contracts have gone down a path of extreme risk allocation, or what investment bankers like to call total risk transfer. As we all know, some risks just cannot be transferred. If the ultimate manifestation of a risk being assigned to a contractor is that halfway through the project, the contractor goes broke, that doesn't actually remove risk for the principal, because the principal is there left with a project which is incomplete and a contract which is broke and having to pay a premium to complete the project. So I do think that this sort of thing reinforces the message that not all risks can be allocated to the contractor. Risks need to be managed and shared, and there needs to be an equitable risk management approach that's taken to these things. And more than seeking to lay blame or trap people, it's all about engaging early in how to manage these types of things. This doesn't mean that the contractors will not assume risk altogether. It's just that means that things like this, which are often by default the contractor's risk, will need to be better managed.
We've got a question just come in, Ted. How likely do you think clients will be to enter a standstill agreement? The view is that this seems to be a good idea.
Well, I think that's a good question. What I'd start by saying that the proposals that the TMR are developing are probably going to be an example to the industry, the broader industry, about how to approach these things. I would imagine that recognising that in circumstances such as social distancing and things like that, the capacity of all parties to deal with the administration of the contract is limited. That provided that no one's prevented from exercising their rights ultimately, and provided that communication is maintained, counterparties, principals will be happy to see contractors engaging with them and how to best manage the dispute. There's absolutely no point in getting into a fight about what the possible consequences of this event will be now, in circumstances where we're not even necessarily halfway through it. And so I think, look, I'm sure that I'll be proven wrong, but in some cases, but I think most principals will engage positively with a sort of proactive engagement approach. But that has to happen all the way up and through the supply chain. So larger projects, for instance, where there are multiple parties involved at different levels, will need a broader conversation. It will be more difficult, but I think that it makes sense, and it's consistent with what the government's talking about in terms of hibernation.
Okay, thanks, Ted. We have got an exciting initiative to announce later on in this breakfast, where you'll be able to ask questions of industry experts like Ted on an ongoing basis during this current pandemic. But for now, thanks, Ted.
Thank you.
So I'd now like to introduce Matt Smith, Principal Lawyer, DWF, who is Head of Employment, Safety and Regulatory at DWF. Matt advises corporate and government clients on safety, regulation and industrial relations. He specialises in assisting clients to resolve highly sensitive issues in often acrimonious litigated matters. Matt has over 20 years experience and works predominantly with government and major corporate entities in the transport, construction, mining and resources, manufacturing and retail industries. He has extensive experience in the legal and strategic management of serious safety incidents, advising on incident management from the day of the incident up to and including management of safety prosecutions and coronial inquests. Matt has successfully defended dozens of regulatory matters, including several large safety, transport and environmental prosecutions. He is skilled at resolving workplace issues and restoring relationships between unions, the workplace and regulators with minimal business disruption. Matt draws on his significant career experience as a highly trained industrial relations practitioner and advocate for industry and government, and as a counsel in various courts and tribunals to settle disputes in highly confrontational circumstances. He regularly appears in safety, industrial and employment matters before various state and federal courts and tribunals. Over to you, Matt.
Thanks very much, John. And as with Ted, that was a very, very kind introduction. I want to make a few opening comments before I start, and forgive me if I'm stating the bleedingly obvious, but I think it's important to bear it in mind when you're dealing really with three categories of, I guess, legal issue at a time like this. The first one is the employment or industrial relations issues. The second are the safety issues, and the third are the compensation issues. And all of those very much go hand in hand when you're managing a large workforce, or you're managing contractors with subcontractors with significant workforces as well. I suppose the comments need to be looked at in this perspective. And Ted made a very salient point earlier, which was that a lot of the legislative background to all of this, it's not fit for purpose. So in an employment and a safety and a compensation perspective, these laws have not been designed with this sort of scenario in mind. They are not fit for purpose. And ultimately what that means is that questions of reasonableness are going to enter the fray. What it also means is that to some extent, there is going to need to be, in different scenarios, a little bit of crystal ball gazing in terms of what we think courts may or may not say in terms of resolution of issues, whether that be the Fair Work Commission, whether that be state magistrates court for a safety matter, whether it be the QIRC looking at a question about whether or not contracting coronavirus at work is compensable injury. So there's a fair bit of crystal ball gazing there. But I'll try and address all of those. Now, as a result of all of that, there's a real lack of flexibility in the system. So although there are some hard and fast rules that I'll be talking about, there's also steps that you can take as long as they are reasonable to manage a bunch of these issues. So it's all perfectly manageable. Now that lack of flexibility will change over time. So for example, this isn't applicable to the construction or resources industry at the moment, but you might have heard about pandemic leave, and there was a call made for submissions just last week, I believe, by the Fair Work Commission. They wanted to issue a decision that effectively would change a whole raft of awards, not in relation to construction, a whole raft of awards that would introduce this concept of pandemic leave. And what it effectively was going to allow was to allow people to take unpaid leave for a couple of weeks. It's also meant to allow people to take annual leave for an extended period at half pay. So in other words, effectively, if you've got 3 weeks worth of work leave accrued, you can take 6 weeks of leave and your employer has no choice about that, but that leave is paid out at half pay. That's an example of the flexibilities that are being introduced almost on a weekly basis now by the Commission. We're expecting a decision to come down in relation to that probably on Thursday. I think that's going to be handed down this week, and there'll be more information sent out by the QMCA in relation to that. Although it doesn't particularly apply to construction, it will be applying to clerical and other staff. So for everyone involved in this presentation today, you will have people who are impacted by that, and it does create new rights for them and things that you need to be aware of when you're provisioning in future. So that pandemic leave is a good example. Another example is amendments to the Clerk's Private Sector Award, where you might have people that are potentially covered by that working in the office or otherwise. The changes that have come in about that are your abilities, and it actually allows again for more flexibility. So it's opened up the hours of work. I won't go through all the details of it now, but for example, it allows you to agree with people that they work a far greater spread of hours in clerical work and so on. So you just need to be aware of that. That change has occurred in hospitality. That change is occurring in the Clerk's Private Sector Award. That will probably be introduced more broadly in other awards. We'll just have to wait and see where that sits as well. So those are the sorts of changes that are occurring from I guess, a Fair Work Commission perspective. I think when you're looking at the reasonableness of the steps that you take in terms of managing a workforce, the operative word is going to be reasonable. I'll talk about that in a little bit more detail when I talk about directions that you might be issuing to employees. But the thing to always bear in mind is a court will look at the reasonableness of what you've done. One of the unfortunate realities of this scenario, though, and you need to bear it in mind, is although someone might raise an issue in a court, they may not raise it now, they'll raise it at a later point in time. And it might well be that all of this is done and dusted, And the unfortunate reality is we might have a court looking at it with the benefit of hindsight over what best practice might have been, and we'll have to deal with those issues then. So the hard and fast rule you should always look at, and the thing that you will always be most successful in arguing is that steps that you might have taken were reasonable in a particular circumstance. So remember to bear that in mind. So from that employment perspective, there's a few things I'll talk about in a moment. From a safety perspective, I think you can expect that the regulator is going to be taking action, and we've seen them actually quite active. They haven't diminished their level of regulation in the construction industry by any stretch of the imagination. We've seen a plethora of notices being issued and in a whole range of different contexts. I should say we've also seen specifically coronavirus improvement notices being issued. And the coronavirus improvement notices we've seen issued have largely related to distancing. So, you know, if people, for example, are not 1.5 metres apart part of each other when they're lining up to sign on to come on site or whatever it might be, and there's not appropriate markers put out, we've seen the regulator raising issues in relation to that. So in terms of the safety guidelines that are being issued at a federal and a state level, it's important to bear those in mind and to look at your existing safety systems and make sure that everything that you're doing is consistent with that in the workplace, because you do face the risk that the regulator will come in and they will issue notices and they will take action if you're not complying with those federal and state directions. And that distancing, that 1.5 metres, is an operative one. We've seen it happen. So it's not a theoretical risk, it's an actual risk. So remember to bear that in mind. The last, I guess, well, third issue we'll be talking about is compensation more generally. And one question that we've often been asked is, well, if someone catches coronavirus at work, is that a compensable injury? So can someone make a statutory claim? And the answer to that question is yes. So if you can draw a nexus, sufficient nexus, I mean, it's a no-fault scheme, but clearly if they can draw a nexus between someone catching the virus and the workplace, that would be a compensable injury. And we expect there'll be a few cases that get raised in relation to that. And ultimately what the evidence will turn on when the courts look at that will be the expert evidence from doctors about probabilities or likelihoods about whether they caught it in some other context or whether they caught it in a workplace context. So that's important to bear in mind. And it's significant to note that the medical profession have been pretty sophisticated in terms of their ability to narrow down where individuals may or may not have contracted a particular virus. I mean, they can't ever be 100% certain, but I've been very surprised at the level of sophistication they've been able to bring to bear in terms of identifying where someone might have otherwise caught the virus. So if there is that nexus between the workplace and someone catching the virus, no fault scheme, they'd likely be able to bring a claim, a statutory claim. Whether they can bring a common law claim is another question entirely, and I won't go through those details for the purpose of today's presentation. What I will talk to, though, is a few, I guess, frequently answered questions that we've had raised time and time again across a whole range of different matters that have been brought up. So, Ted, if you could go to the next slide, please. Right. This is probably the bluntest question that we've received. So I guess from an employment safety perspective, what do you do if an employee is diagnosed with the virus? And forgive me for those who might have been through this process already, or already turned their mind to it. There's obviously different levels of sophistication in terms of how people might have dealt with these issues. So there's a few things we would recommend. Obviously, that employee should be directed not to attend work until they're well. Now, when someone has got the virus and they go home, they're entitled to access their personal leave. But for ease of reference, I'll call it sick leave for the purposes of today's presentation. But under the Fair Work legislation, it's actually referred to as personal leave. But I'll call it sick leave because it's just, everyone knows what that is. So they can access their sick leave. Now, if someone is unwell, they've used all their sick leave, they can then access their annual leave, and they're entitled to do that. Now, beyond that, there is no general entitlement, I should say, and I make this observation, there's no general entitlement for them to receive payments from you or payments from their employer. So it's important to bear that in mind. When you send them home, you should advise them to seek medical advice, obviously. Any employees who've been in close contact with that affected employee should be directed not to attend work for 14 days, so they need to isolate. And so you should be sending them home. Now, the thing about that is, and it's important to bear this in mind, what you're doing in that case is you are directing people who are not sick to stay at home. Now, if they can work from home, that's not a problem. You can set them up at home, they continue to work, no issue, they're still productive. If they're unable to work from home, but you've directed them to work from home for that period, so they've got to isolate for that 14 days, and that's the appropriate thing to do in any event, you are required to continue to pay them. And that's an important thing to bear in mind. There are a couple of exceptions, but the general proposition is this. If someone is required by way of government mandate to stay at home, so effectively they're stood down by way of a legislative intervention, and there's provisions under the Fair Work legislation which talk about that, then you don't have to pay them once they've used their annual leave, etc., or if this pandemic leave kicks in, etc. But if someone has been asked to stay at home and they're in what we'll call an essential industry, so construction, which is an essential industry, but it's done by way of your direction and they cannot work from home, the expectation is and the requirement is that you would continue to pay them for that period. And that's an important distinction to bear in mind. I've already talked to you about their access to sick leave. I think you should also tell those, I'm just referring to my notes, forgive me, you should also direct those who've been in close contact with an affected person, obviously to get medical advice, and you should require the affected employee to produce medical clearance before returning to work. So it's not unreasonable for you, if someone's been diagnosed with coronavirus, it's not unreasonable for you to say, look, we don't want this person coming back to work for the obvious risk that it creates for health and safety until they get appropriate medical clearance. And you want to make sure that medical clearance specifically addresses the issue of coronavirus. So, you know, just a general certificate saying they're fit for work from some GP, I wouldn't accept that. What you would be better off doing is requiring a certificate that specifically says they are entirely clear of coronavirus. So that way there's no risk. Because it's important to remember that the people that you're sending home who otherwise can't work at home, they might not have significant cash reserves, they might not have any sick leave left, they might not have any annual leave left in terms of payment. You're not required to continue to pay them where there's that risk that exists. So they might be desperate. So be careful and be watchful in relation to that. You need to inform your workforce. So keep them informed about possible exposure to the virus, but you've got to maintain the confidentiality of the affected employee. So you need to be careful about how you couch that, but make sure to keep your workforce informed. It's also important to bear in mind that a lot of this stuff is very subjective. So you're going to have some people who are dismissive of it, and you've got to make sure you bring those people on the journey with you who are dismissive, but you'll also have some people who are extremely paranoid about it. And again, you'll have to bring them on the reasonableness journey with you as well, because some people will want to take steps or have things done in the workplace which you probably don't need to do. I'll give you an example. It might be that if there was a worker who'd gone into a crib room, it turned out later that they had the coronavirus. What we would recommend in those circumstances is that obviously all the steps I've already advised, but that crib room then be given a thorough scrub and clean. I think the term people are using is a deep clean. Now, some people might then be unreasonable and say, well, that's it, you've got to shut the site down and it can't reopen again, blah, 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 for a period of time. That would be an excessive response, and you should resist that sort of response. One of the things that we've been recommending to our clients, and we've been very robust about this, is that shutting down a site is absolutely a matter of last resort. I've already observed that if the employee was working in the office, it should be cleaned thoroughly during that process. And if they're working on the building site, and this has happened on a few occasions where people have been suspected to have been carrying coronavirus, and they've worked in certain discrete areas or areas of the building site, to the extent that you're able, what you would do is you might close down that particular part of the site while it's cleaned for a couple of hours and then reopen that particular area. And that's something that we've seen done pretty commonly. In terms of things to be doing on site, in terms of the facilities to provide, obviously none of this replaces the advice of an excellent hygienist, so we'd recommend you getting advice in relation to that. But the sorts of advice the hygienists have been giving are this, and I'll outline them just so that you know. The first one is provide hand washing facilities and make sure they're obviously kept clean and properly stocked and in good working order at all times. These are the sorts of things I should say that workplace health and safety inspectors will be looking at when they go out and visit sites. Obviously provide alcohol-based hand sanitizers, tissues and cleaning supplies. Promote good hygiene practices, and that includes displaying posters on hand washing and respiratory hygiene. That's very important to keep in mind. Make sure that you keep the workplace clean and hygienic as much as reasonably possible. So in other words, at this point in time, with the pandemic going through the community, your cleaning would probably be a lot more regular and a lot more thorough than it might otherwise have been. Obviously, regularly clean high-touch surfaces such as door handles and workstations, though they should be cleaned repeatedly every day. Encourage workers who are ill or with respiratory illnesses to stay at home until they've recovered. So, for example, we've had people, I had a cough myself, so I stayed at home for a period of time until my cough cleared. So that's always a sensible precaution to take. So your threshold in terms of asking people just to stay at home or suggesting that they stay at home until they get better, the threshold should probably be a bit lower. Right. If I could have the next slide, please. Okay. Now, as you'd all be aware, there's obligations to notify the regulator of notifiable incidents. This is an example where the notification regulations probably aren't really fit for purpose. So generally, you notify where there's a serious injury or illness or there's a dangerous incident. Now, a serious injury or illness includes an injury or illness where someone has to be treated as an inpatient in hospital or medical treatment within 48 hours of exposure to a substance. Now, that substance could include the virus. So in pretty limited circumstances, there's an obligation to notify the regulator, we say. But if, for example, you've got people who, if you've got someone in your workplace who's been diagnosed with the virus, and people have been exposed to an area where they might have worked, so crib room, whatever it might be, our view is that there would be an obligation to notify in relation to that. But there would be arguments about that, but my view always is that if in doubt, you should notify. So if that occurs, you should notify the regulator and put that in. If you could go to the next slide, please, John. Okay. Now, the answer to that question lies in the question itself. It is okay to require employees to work in the office in the current environment. It depends upon the reasonableness of the request. And the things that we looked at in relation to reasonableness will be their ability to work from home. So if you've got employees who, whilst it's ideal to have them working in the office, but they can properly and effectively do their work from home, then it would likely be unreasonable if they had concerns about working in the office to require them to work in the office. It's just a reality of what we've got to look at these days. By contrast, if you've got an employee and they cannot do their work from home, and as long as you're making sure you're complying with the government guidelines in terms of distancing and so on, which might apply in a particular circumstance. So as long as you're complying with all of those requirements, then it would be a reasonable lawful direction to require them to work in the office. Now, that's where this issue though comes in of it being a subjective situation. So you are going to have some people who are more, I don't like to use the word hysterical because it's a very serious situation, but some people who get carried away about their exposure or the risks of exposure in an environment which is being properly managed and their risk of exposure is almost negligible. There are some people who will just simply not want to come into work. Given the risk that if you direct someone in those circumstances to come into work, and the risk I'm talking about is the risk that they might claim that they suffer a psychological injury as a result, you just have to be alive to that. So if you've got someone who, for whatever reason, let's say, and I'll use an extreme example, someone who's a total germaphobe, and they're going to extreme measures in relation to it. They're saying, no, 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 I don't want to come into work. I think you need to be very careful about directing them to attend work in circumstances where they might try and claim an injury. Now, a psychological injury. Now, there are defences, you know, reasonable management action taken in a reasonable way, but again, you need to deal with this on a case-by-case basis. In our experience so far, most workers are pretty reasonable, and most workers are actually quite keen to come into the office if they're able, as long as hygiene is where it needs to be. So this isn't an issue that'll hit most of you, but there will be from time to time one or two people where you might have to turn your mind to it. And even though you would otherwise be entitled to give them a direction to work from the office, it might be that you elect to go the other way. So it's important to bear that in mind. If I could have the next slide, please, John. I'll deal with this. This was a bigger issue a couple of weeks ago. This is moving so very quickly. And that's about someone being obviously returning from home and being paid as a requirement to self-isolate. The problem you've got is, again, the Fair Work Act is not fit for purpose. So it doesn't yet provide for leave in this situation, but that's why, for example, you've got pandemic leave, which I talked about at the beginning of my presentation. You've got pandemic leave being introduced. So, but that's applying to clerical type or other employees. It's not going to be applying to construction employees, which is unfortunate. And it might be that changes over time. Basically, there's a rule of common law which says that if an employee doesn't work, they're not entitled to be paid. Therefore, if someone's self-isolating on the basis of returning from work from overseas, there is no automatic entitlement to be paid by you. Now, some employers have elected to pay in those circumstances, some haven't. The other alternative is obviously that someone who they're not sick, so they can't draw on sick leave or personal leave. They've got to self-isolate for that period of time because they've returned from overseas. They can access their annual leave for that 2-week period if they need to be paid. And that's usually a pretty sensible, compromise. So just bear in mind that there is no automatic entitlement to leave in those circumstances. Typically, it will be annual leave that you will turn to. But where you've got clerical employees or other employees where pandemic leave will apply, and keep an eye on that from this Thursday, and no doubt John will send out a note in relation to this, they might be entitled to access pandemic leave for that period, or access extended annual leave over a period of time. John, if we could go to the next slide, please. Okay. Looking after children due to school closures, taking personal or carers leave. Now, you can access, so an employee can access personal leave or sick leave, I'm calling it, but it's personal leave. You can access personal leave where you've got people we've got people who have to go home because school has been closed. They can access that leave because it's an emergency situation. So what will be happening after Easter in relation to the schools? I haven't actually checked in the Queensland context if the schools are going to be shut down. I know that it can vary from obviously private schools, there's state schools, the steps that are being taken. But if your employees find themselves in a position where their schools after Easter are going to be shut, they arguably and probably could take that leave. Now, if that continued for an extended period of time, because I know there's some people with absolutely vast amounts of personal leave available to them, I think after a period of time, it's probably reasonable for you to require for them to make alternative arrangements in terms of the care of their kids. So, but we'll just have to see how that develops, and we'll have to see how the government directions develop. But for the next couple of weeks, I think it's better to operate on the basis that they're able to adequately access that personal leave to look after their kids. One thing to note about that though is this: if they have other arrangements, so if for example, you know that they're married and their husband or their wife is staying at home in any event, so they've got other reasonable arrangements available to them for the care of their kids, then they can't reasonably take personal leave at that point in time. The other thing to bear in mind is in relation to any casual employees you might have, they can take up to 2 days per occasion of unpaid emergency personal leave. John, I think that's the last one. If you go to the next slide, please.
Yeah, thanks, Matt. Very good presentation. I'm seeing that we've probably got quite a few questions coming through on that, so I'll try and pick out some. What is the likelihood at the state or federal level on whether construction will be totally shut down, similar to Ireland? Might be crystal ball gazing that, but what's your views on that?
Ted and John might have a different view from me in relation to this. It's going to have to be close to Armageddon before the government directs that to happen, I would have thought. I'd be surprised. I would be very surprised. I think it's pretty clear that the Queensland government and the federal government have made it clear that they're going to be extremely resistant to taking any step like that. Ted, you might have an observation to make about that.
I agree with that.
Yeah, and I would agree with that one as well. On the basis that COVID-19 may be here to stay, what amended new WHS measures will need to be written into contracts, thinking in particular of FIFO arrangements?
Yeah, so there's some FIFO, actually. If you have a look at, there's some directions that have been issued by the state government just recently in relation to FIFO, and particularly in relation to mining. And I believe that they started just a couple of days ago. I can't really answer that question now in terms of all of the other amendments you might want to include in your contracts, because it's a pretty extensive question. But that might be something, maybe that's something that we look at for a separate seminar, John. Or alternatively, I'm happy to look at it or talk to that person individually about it, but there'd be an extensive range of changes you would want to make.
Okay. What if the social distancing rules are relaxed, but staff are uncomfortable to be put in close situation because they consider the risks too high personally? Okay.
So again, it's that issue that I was speaking about a little bit earlier. So if those rules get relaxed, then the requirement is simply that you follow whatever the rules are. If you've got employees who decide that they don't want to go to work and they can't work from home, but they don't want to go to work because of that, it's actually quite reasonable of you to direct them that they should attend work in those circumstances, because those rules would only be relaxed based on good medical advice. And we can only accept the good medical advice that we're getting from the state and federal governments. Where you directed an employee to attend work and they didn't in those circumstances, it might be that that's a lawful and reasonable direction, and you could consider potentially, at the outer limit, you could look at termination. I'm not saying that should be your first port of call. Probably your first port of call would be to have a discussion with that employee, explain to them that those measures have been relaxed, they can't work from home, they're a good employee that you want to try and keep, but you also can't justify paying them while they're sitting at home for this period. So that might be the discussion that you have with them at that point in time. If they don't otherwise have access to pandemic relief, which might be introduced in the construction industry.
Okay, if Ted's still around, just one question, which is probably aimed at you, Ted. Do we look at amending subcontracts / supplier agreements going forward, as well as a lot of pain will be felt there?
Yes, I think the answer is yes. These amendments will go up and down the supply chain. So definitely there's a need to amend subcontracts in the same way. In fact, on my understanding of the requirements or the proposals that are under discussion from the Transport and Main Roads, it's also a requirement of what they're considering that the same reliefs are provided down the subcontract chain, which would make sense. What I would say about amendments to contracts going forward is that we're probably at a little bit of an early stage to be considering those things for now in terms of permanent changes. But yes, I think that the risk allocation, to the extent that it happens, that head contracts will also change and be consistently applied in subcontracts also.
Okay, thanks Matt, thanks Ted. We're running slightly over time. Apologies for that. Hopefully you don't all have meetings to dash off to. I'm pleased to say that we've had close to 130 people tuning in for this breakfast, which is really good. So what I'd like to finish off on now is some more general QMCA news, and obviously again it's sort of very heavily focused on COVID-19. But before we get there, I'd like to welcome new members, DWF. Obviously we've just seen Matt from DWF, and Hastings Deering. It's in times like this that I think that industry associations come into their own, but we're only as good as the support that's given to us by our members. So QMPPR, we were hopeful right up to the last minute of having a live launch of the Major Projects Pipeline report. Straight after ScoMo saying he was off to his Sharks game, we thought we were still on. Unfortunately, things were moving very quickly, and we had to take the decision to run a virtual event instead. But what our plans are with the QMPPR is still to hold another event later on in the year, which will be, we'll use updated data for this, and it will be very much focused on recovery effort and how the pandemic is, the effects of the pandemic will play out on the industry. So everyone that has a ticket to that launch event, that will still be valid for the revised event, hopefully later on this year. So what is QMCA currently doing? There's a lot going on behind the scenes. It is really quite heartening, I guess, to see just how much is going on behind the scenes currently in terms of preparing or keeping projects working, but also preparing for the other side, as people are calling it, when we get either find a vaccine for COVID-19, or we get that so-called herd immunity. In partnership with CCF, we submitted 2 papers to Department of Transport and Main Roads, one which was focused on how do we keep projects going currently, and how do we address the commercial and contractual issues that Ted addressed early on. I'm pleased to say that those proposals appear largely to have been accepted. We have some meetings with DTMR today. They've drafted some changes which we're currently reviewing, and hopefully a guidance note will be issued very, very shortly for that. They're also looking to address future contracts as well, and incorporating these revised terms and conditions into future contracts. The second paper that we put together with CCF was focused on the recovery, the other side, and it was looking at opportunities to basically reduce cost of tendering, to expedite projects, to shorten the tender process, largely through use of more collaborative forms of contract. And I'm pleased to say that again, the initial reaction from DTMR has been very positive. There's still a wee bit of way to go with that one. It's not just necessarily a DTMR decision. with some of these projects because especially where federal funding is involved. But at least the discussion is ongoing with them, and it's a very good discussion. We are working to ensure that projects continue to operate through discussions with government on border restrictions and safe operating guidelines, some of what Matt was talking about there around the measures that as an industry we agree are necessary and appropriate to keep our projects open and running. We're supporting, working very closely with other industry associations such as IAQ in terms of the work that they're doing. They are looking at things, different aspects of this, in particular the possibility of the creation of a recovery agency, which we're very supportive of. And we're also members of the newly formed Queensland Response and Recovery Coalition. In terms of a bit of project updates, we have heard that ARTC in particular has been given the green light to press on during these times. We've also put some pressure on BCC to get a bit of a wriggle on now that they have been, the council elections are out the way, and we understand that a project award for Brisbane Metro is imminent. If there is a silver lining to the big dark cloud that is COVID-19, it's the possibility that it provides us an opportunity to reset how industry operates going forward and set us on a more sustainable path. I think Ted touched on some of the things that might include, but it's a path that involves increased collaboration between all industry stakeholders, and a path that takes a partnership-based approach to risk allocation. A path also that considers project value more than just on terms of costs, but how appropriately to reward contractors for delivering increased value. A path also that provides project owners with increased certainty of outcome. A path that provides a platform for investment in people, processes, and new technology. But most importantly, a path that makes our industry a better place to work, more attractive to the next generation of industry workers. QMCA is actively working with other industry associations, with this goal being an absolute priority. This particular slide covers off on a couple of things. Construction Aerium, that's the picture from the all-female Construction Aerium build. Obviously, Construction Aerium's activities are currently on hold, but Harry Hartman does advise me that they'll be coming back bigger and better out the other side. Building Bridges is also the new name that we've given, and probably more appropriate name that we've given to the truth and reconciliation process between contractors and design consultants. Following the 2 workshops we had last year, we've finalized 5 working groups to investigate solutions to some of the problems that those workshops uncovered. And there is also the potential that DTMR may become involved in this process as a sponsor. We'll be shortly asking those working groups to commence their work, but obviously mindful of everything that's going on, we'll probably have to push back our original timeline for when those working groups would reconvene and have some further workshops where we try to agree on the way forward and actions to be taken. Finally, I'm pleased to announce the QMCA Brains Trust. So what is the QMCA Brains Trust? Well, in difficult and uncertain times like this, and as we've seen from the questions that have come through after the presentations, there's a lot of uncertainty out there. People have got a lot of questions that they would like to ask and don't always know where to go to ask those questions. So what we've done is we've formed a Brains Trust of industry experts comprising members of QMCA. And we'll shortly be putting up, if it's not already up there, a form on our website where you can put and ask your questions to the Brains Trust. and where appropriate, we'll be sharing those questions and also those answers. But there will be the opportunity as well, if you want to continue on your conversation with that particular expert privately, then there will be the opportunity to do that as well. Well, it's time for me to wrap up. I will take some questions if we've got some questions. I'm just looking to see whether we've got any questions here from everyone. No, I think we're still looking at the questions to Matt there, but if anyone had any particular questions that they would like to ask, here we go. How does one get involved in building bridges? So this is a joint initiative between QMCA and Consult Australia, and we have, if you are a member of Consult Australia, I suggest that you contact them. It's still possible to get involved in these working groups, and I've got a demented spaniel who's trying to get out of the room at the minute. This is the joys of live a live presentation. I thought I managed to get all the way through there without any problem at all, but my spaniel Daisy has got in the way. But so yes, how do we get involved? If you are a QMCA member and you would like to get involved, you can contact me directly. That is one way. We had put out a number of emails to the membership earlier inviting people to take part in this. But if you want to get in touch with me, it's not too late. We're always interested in people that are keen to be active and involved. So I think that is all the questions. So look, I'd just like to thank once again our speakers, Matt and Ted. Like a lot of people, we're sort of working our way through this, and with this idea of a virtual breakfast, hopefully you've all found it informative and useful. I'd particularly like to thank Struba for helping us pull all this together at pretty short notice. If you do have any sort of comments in relation to the style of it or any suggestions on how you would like to see this going forward, whether you'd like to see us do it again or not, then please get in touch with me. But other than that, it just leaves me to say thank you very much once again. Please stay safe and have a great day. Thank you.